Fundamental to the work of this court is a recognition that it is only one of three equal branches of our government. The role assigned to the court is not to create policy, and it's not to judge the wisdom of any particular policy promoted by the other two branches. That is the work of the legislative and executive branches, and the citizens who ultimately, by exercising their rights to vote, exercise democratic control over those branches. The work of the judiciary is limited to ensuring that the actions taken by those two branches comport with our laws and, most importantly, our Constitution. There is a very narrow question before the court today that asked to be considered, and that is whether it is appropriate to enter a TRO against certain actions taken by the executive that are enumerated in this specific lawsuit. Although that question is narrow, the court is mindful of the considerable impact that its order may have on the parties before it, the executive branch of our government, and the country's citizens and residents. Federal defendants and all their respective officers, agents, servants, employees, attorneys, and persons acting in concert or participation with them are hereby enjoined and restrained from A. Enforcing Section 3C of the executive order, B. Enjoined and restrained from enforcing Section 5A of the executive order, enjoined and restrained from enforcing Section 5B of the executive order, or proceeding with any action that prioritizes the refugee claims of certain religious minorities, enjoined and restrained from enforcing Section 5C of the executive order, and lastly, enjoined and restrained from enforcing Section 5E of the executive order to the extent Section 5E purports to prioritize refugee claims of certain religious minorities. This TRO is granted on a nationwide basis and prohibits enforcement of Sections 3C, 5A, 5B, 5C, and 5E of the executive order at all United States borders and ports of entry pending further orders from this court. I considered the question of the government's request that the order should be limited to Minnesota and Washington, but I find that such partial implementation of the executive order would undermine the constitutional imperative of a uniform rule of naturalization and Congress's instruction that immigration laws of the United States should be vigorously and uniform. That's language from Texas versus the United States, 809 Fed 3rd 134 155, 5th Circuit 2015. I find that no security bond is required under the Federal Rules of Civil Procedure 56C, and I direct that the parties confer and get back to the court promptly. Today wouldn't be too late, but by next week, regarding a date for the preliminary injunction hearing, the time for the motion for the preliminary injunction, the time for the federal defendants to file their opposition, and for the states to file their reply. Once we know that, we'll promptly schedule a hearing on the motion for preliminary injunction after we are in receipt of the parties' briefing. The court concludes that the circumstances that brought it here today are such that we must intervene to fulfill the judiciary's constitutional role in our tripart government. Therefore, the court concludes that entry of the above described TRO is necessary, and the state's motion is hereby granted.